Hi, welcome to this afternoon's lecture series. I want to first thank the sponsor, MRV Architects, and we have some series friends who are also sponsors, McDowell Group and Kathy Ruddy. We appreciate their participation. I want to take the opportunity today, and I appreciate the opportunity to introduce Rosita Worl. Dr. Rosita Worl received her PhD in anthropology from Harvard University and taught anthropology and ANSCA courses at UAA and UAS. She has extensive academic background and is widely published. She has also received national and statewide awards for her work. In 2008, the National American Anthropological Association bestowed upon Dr. Wuerl the prestigious Solomon T. Kimball Award for Public and Applied Anthropology. Dr. Wuerl is also featured as an anthropologist of note, as an applied anthropologist in the text Cultural Anthropology, The Human Challenge. In addition to her leadership on Alaska Native corporations and organizations boards, Dr. Wuerl has spent decades studying ANSCA. From 1982 to 1987, she was publisher and editor of the Alaska Native magazine, which examined Native issues on a state level. Additionally, from 1988 to 1983 to 1985, she served as a special advisor to Thomas R. Berger and Alaska Native Review Commission to re-examine ANSCA. More recently, Dr. Worl has been involved in an NSF grant which seeks to measure and understand the impact of Alaska Native corporations today. That is the written word on Dr. Worl. I want to take just 1 minute to talk to you about the personal human side of her. Dr. Rosita Worl and I, before she was doctor, attended Alaska Methodist University together. We graduated together in 1973. The note here is that she attended University of Alaska and Alaska Methodist University almost at the same time and was able to graduate in a very short period of time. She started her career in education pretty late, actually. Had children already when she went to college. Received her degree in 1973, the same year I did, and our keynote address speaker that year at Alaska Methodist University was Dr. Walter Sobola. Mm-hmm. Yeah. We were really privileged then to have him be our keynote speaker. She went on to become a student at Harvard, which in itself is noteworthy. To become accepted at a prestigious university in America, like Harvard University, has to be recognized as an achievement. But to also get a PhD in anthropology from that prestigious university is also noteworthy. And very few of us have ever done that kind of academic work, and especially someone like her to have not only done the work, but to have exceeded and done awfully well in it. She has followed in her Clinkette tradition as being a great orator. Since I've known her, she has grown tremendously in her oration. And it's really something that those of us who are from Clinkette descent are very proud of, is that our tradition, Clinkette tradition, has been an oration tradition. And she is very, very well versed in that area. I really appreciate Dr. Worl. She has been a leader not just in anthropology, but in the state Native Association, the state in itself, in issues that are important to all of us. So would you please welcome Dr. Rosita Worl.
Thank you very much, Albert, for that very kind introduction. I'm reminded that when we were at AMU walking up the aisle to get our diploma, I think we were fighting then, and sometimes we still continue that, sometimes in public, as we forget when we have our differences of opinion. I'm also reminded that about the written word and oral traditions. When I first became enthralled with the idea of writing, I was doing an introduction for the Marks Trail Dancers for on the Wickersham. And I'd written out my introductions, and I lost my place. And people said all they could hear on the radio was my crinkling of the papers while I looked for my place. So I've become very dependent on the written word. Today we have a very complex topic, and to try to address it in 45 minutes or so is also very complex, but I'm going to try to do the very best that I can. What we'll do is move very quickly through the first part and then spend a little bit more time on really talking about assimilation. But first, if I could, in honor of my ancestors and in love for my children, my grandchildren, I would like to introduce myself to you in my Clinkette traditions. Clinkette Khainach Yedeklatsak Ka Kahani Aksai Shangu Kwedi Ka Jak Nachatsati, Kaudli Ayihit Ayachat, Jilkat Kwan Ayachat, Sukachadi Yadi Ayachat. My Clinkette name is Yadeklitzak, and my ceremonial name is Kahani. I am of the Thunderbird clan of the Eagle Moiety, and I am from the House Lord from the Sun in Klakwan, and I'm very proud to be a child and grandchild of the Sakai clan. You've heard that I've done a lot of research on ANCSA, many years, but this particular research project is the same project as the one that Dr. Tom Thornton talked about when he was here a couple of weeks ago. It's a National Science Foundation study. We're comparing the Bering Straits region and Sealaska. We're looking at 4 major components that are identified up here. And in this address, I will be looking at the 4th component, cultural conservation and revitalization strategies. And specifically, I will be focusing on the question of assimilation. To assess the question of ANCSA's impact on assimilation and the cultural survival of Indians of Southeast Alaska, I will review first of all the following principles: the legal principles and policies governing Alaska Natives, the responses of the Clinkette and Haida to colonialism, and then Alaska Natives' initiatives to integrate Native values into ANCSA. But first of all, let's take a look at what is assimilation. Assimilation is a process of change in which a culturally distinct group adopts the patterns and norms of the larger society and abandons its cultural traditions. That's what assimilation is. A very closely related topic, concept, acculturation. Acculturation is the process of disruptive and massive cultural change involving an element of force occurring in a society when it experiences intensive contact with more powerful society. That's acculturation. And then we have a third concept that I'd like to introduce you to, and that's forced or directed assimilation. And this is when a dominant group attempts to destroy a culture or a tribal group and forces them to adopt to the dominant culture. For example, banning native religion, languages, and customs. Now let's look at the legal principles relating to Alaska Natives and the federal Indian policies. And why do we want to do this? Because to understand sociocultural change and assimilation among Native people, it's important to understand the legal realities and the policies that promoted change in the lives of Alaska Natives. Previously, anthropologists have studied environment. They looked at environment. How did environment affect Native society, indigenous societies? Well, in more recent times, and the recent times now is not so recent, but 20, 30 years ago, we began to look at the political realities and how the rules of the larger societies affected indigenous groups. More often it's assumed that indigenous groups are passive recipients, that they just kind of meekly go along with the changes that are going on in their life. More often in Alaska, Alaska Natives were not able to overcome the coercive, they're very strongly coercive forces of change that the federal government undertook, and notably that's in the area of land. But the history of Native people challenges the assumption that they were passive recipients. In reality, they took many initiatives to control the influences that were impacting on their society, while they also openly embraced other kinds of changes. This is an important thing to remember. But first of all, let's remember also that Alaska Native people were originally independent, they were self-sustaining, they were able to provide for themselves in their traditional cultures and economies. However, in the last 270 years since the arrival of Westerners, and the historical and the ongoing interactions with Westerners, the Clinkette and Haida have been very clear and consistent in maintaining that they were the owners of Southeast Alaska. The Clinkette and Haida also had well-established commercial relationship with the Indians in the interior, and they traded all along the coast to the northern areas of the Oregon coast. And so when the Westerners arrived, they were familiar with commercial trade, and they openly embraced and welcomed the arrival of the Westerners for the trading opportunities that they brought. The first legal principle I'd like to introduce to you is the principle of discovery. And this is a legal principle that the civilized nations of the world adopted, and they said that the first nation that discovered an indigenous society in the Western Hemisphere had the right of discovery. But I'd also like to note that Native people were not involved in the development of these European agreements. And the resulting legal theory that was developed meant that their interests were not protected. And the principle of discovery held that tribes had right of possession but not ownership of their lands. These possessory rights could be transferred, changed, or extinguished only by the discovery nation, or in the case of Alaska, where the discovery nation purchased or sold to the United States the discovery right. And this nation was then expected to extinguish the Aboriginal title or Indian title. Now, just looking very quickly at the federal-native relationship, Chief Justice John Marshall was the first to really look at American Indians, and he was the first that made some decisions, and they're called the Marshall Trilogy decisions, and they established Aboriginal land title, the federal trust responsibility, and then also the inherent governmental powers of Indians. He made decisions in 3 cases. They're called the Marshall Trilogy. And it's these 3 judicial decisions that continue to serve as the basis of dealing with Alaska Natives. Also important to know is that under the principles of law established by the U.S. Supreme Court, Congress is said to have plenary powers over Native American communities and their members, and plenary powers means that Congress has full or complete power in the field of Indian affairs. And then I've cited the 2 provisions of the Constitution that gives them this right, the Indian Commerce Clause and also the Supremacy Clause. And this is important for us to know here in Alaska, that laws enacted within the scope of constitutional authority are the supreme law of the land and preempt contrary provisions of state constitution or laws. In Alaska, we see this operating in ANILCA, the Alaska Native Interest Land Conservation Act, and over in the area of subsistence, where the federal law recognizes the protection of Native subsistence rights, but the state doesn't. So we have the Supremacy Clause at work for Alaska Natives in this area. Also important to remember is that there is this trust relationship between the federal government and Native tribes. And you very often talk about this legal relationship called trust responsibilities. The United States has a trust responsibility towards Alaska Natives. In looking at federal Indian policy, we see that it's been a vacillating pendulum. On the one hand, we'll see where the government attempts to protect Native life, and then a couple of years later, or the next year, we'll see where they try to extinguish a Native culture and then promote assimilation. Now, what was the Clinkette reaction to colonial rule? In 1867, when Alaska was purchased by the United States, the Clinquettes were fully aware of that. They met. A group of clan leaders met. They were trying to figure out, what are we going to do? Some of the clan leaders wanted to advocate for war, while others said, nope, I don't think we have the military might to win that war. And so they decided not to go to war, but they did hire a lawyer and to protect and advance their rights. The next thing that we see in history is the Clinkette's claim to sovereignty. And this is a case that the Clinkette's brought to court in Rosita in 1886. And here the Clinkette's argued that as an original group, they retain their internal governing authority exclusive of the laws of the United States. And the Clinkets here assert that the federal laws prohibiting slavery did not apply to them because, first of all, they were independent sovereigns, and secondly, that their customs allowed for slaveholding. The Alaska Federal District Court rejected the Clinkette assertion that they were sovereign and possessed the authority to maintain the practice of slavery. The court held that as residents of the United States, they were subject to the 13th Amendment to the United States Constitution prohibiting slavery. Imagine that, the Clinketts bringing a law case like that. With the dismissal of their claims of sovereignty, the Clinketts sought citizenship. And they, in their the Alaska Native Brotherhood and the Sisterhood, they organized to seek their civil rights. And they saw that because they were not sovereigns, that they would have to become members of this political system in order to try to protect their rights. In 1923, we have Charlie Jones of Wrangell going to vote along, assisted by his aunt Tilly Tamery, and they were charged, or they were indicted for voting illegally. William L. Paul Sr., a Clinkette lawyer, comes to the defense of his uncle and his mother, and the case was dismissed, thereby validating the right of Alaska Natives to vote. And this was a year before the actual 1924 Indian Citizenship Act of 1924 was enacted. So what you're seeing here is where the Clinkette people are using the institution of the larger society to protect themselves. Another thing that they did was they started to go to court. And in this case, we have Miller versus the United States in 1947. We see individual Clinketts occupying land here in the Juneau area, and they're contesting the condemnation proceedings of their land. The United States argued that their land was unrecognized Aboriginal title, and that the United States could extinguish their title without compensation. Sounds very much like the next case that we'll see. The next case is the Teton, and here we see William Paul again acting, and under his leadership, the Teton clan out of Wrangell claims the right to compensation under the Fifth Amendment of the United States Constitution for the value of timber taken by the federal government with the creation of the Tongass National Forest. The Supreme Court, and we heard last week Chris McNeil, the CEO of Sealaska, talk about the Teton case, and in this case the Supreme Court rules that the Teton clan did not have any permanent rights to land occupied by them. And again, they ruled that the federal taking of unrecognized Aboriginal title was not compensable under the Fifth Amendment of the Constitution. But it left open the question of whether Alaska Natives had any claims to lands that they occupied. I just add this side note of William L. Paul. You know, William L. Paul was a very significant person in the lives of Alaska Natives. He not only was acting in Southeast Alaska, but he also wrote to the North Slope Inupiat and told them to file a blanket claim for the whole North Slope. In my mind and in my studies of Alaska Native history, it is my assertion that he should be recognized as the father of the Alaska Native land claims. And then we have the Clinque and Haida land claims course in 1929. The Clinketts, you know, at this time we're hearing a lot of protests of Native people about the taking of their land. They're protesting to the federal government. Nothing ever happened. So in 1929, the ANB passes a resolution that says that they're going to move for the settlement of their Aboriginal land claims. And in order to be able to sue the United States government, they had to pass a jurisdictional act, which was enacted in 1935. And this allows the indigenous people of Southeast Alaska to sue the United States government for the taking of their Aboriginal lands. The Court of Claims in this instance ruled for the Clinkette people and the Haida people and said that they had been deprived of their Aboriginal land by the action of the United States, and they concluded that they had use and occupancy rights, and that these rights had not been extinguished by the Treaty of Cession. And they ruled that they were compensated just over $7 million for the taking of Tongass and Glacier Bay. We'd gladly pay that back today and get those lands back. Then the other thing that happened was the Indian Reorganization Act. And I note in here, this is the first time that the United States government employs anthropologists or social scientists to try to help the United States figure out how do we assimilate these American Indians. And the anthropologists came up with the idea that we should shift the initiative of change, to Native people themselves, rather than having the federal government, use all of the coercive, forces that they were trying to use to change Native people, like war. And they said under the IRA that this was to be accomplished through the adoption of democratic forms of government and also business corporations. So we say that the IRA was a kinder and gentler approach to promote change among American Indians, and it replaces the previously coercive policies to assimilate Indians and eradicate tribalism. It was a significant paradigm shift from the individualistic 19th century policies to the collectivist reforms of the 20th century. Now, irrespective of the government's objectives, the Clinkette and Haida of Southeast Alaska saw the IRA. They noted that it had not been extended to Alaska Natives, and they began to organize and work through the A&B to lobby to have the IRA extended to Alaska Natives. They were especially interested in the federally chartered businesses that had access to a revolving loan fund for economic development. So the important thing about the IRA is to remember that it was, again, a creature of Congress. These IRAs were created by Congress. We're hearing a lot of revisionist history today, but in fact, it was a creature of the United States government. But the Native people in Southeast Alaska really liked what they saw, and they lobbied to amend the IRA, which they were successful in doing in 1936, and it was extended to Alaska. And so by 1941, we have 38 groups that are organized under the IRA, the Constitution, and also many of them established business charters. And in Southeast Alaska, we see 15 IRAs were established here in Southeast Alaska. So in 1943, the Department of Interior announced plans to set up reserves at Clinkette, Cake, and Heidelberg. But over on the western parts of Alaska, the department was attempting to prevent non-Native people from fishing on the Clinkette reserves. A group of salmon cannery packers brought suit in the Hines versus Grimes Packing Company, challenging the department's authority to issue the fishing regulations and also the legality of the reserve itself. The Supreme Court upheld the department's authority to establish the reserves, but they prohibited criminal prosecution of non-Native trespassers and characterized the Clinkette Reserve as a temporary withdrawal. The decision negated the department's ability to enforce exclusive Native fishing rights on the IRA reserves and called into question the permanent rights that Native people had to these reserves. A subsequent Alaska federal court case invalidated the Heidelberg Reserve on technical grounds, and it also went further and denounced the department's effort to protect Aboriginal title. By 1952, the Department Secretary Ickes and others in the Interior Department who had supported these reservation programs were no longer in office, and we see the Indian policy pendulum beginning to swing in the reverse direction to the termination of the special Indian-Native relationship. So it's against this background, against this historical background, that we see Native people beginning to organize to settle their Aboriginal land claims. Because they had had such poor experiences with the BIA, particularly with the business enterprises organized under the IRA corporate structure, and then also knowing that the reserves could be revoked, the Native leaders of Southeast Alaska were not inclined to support the reservation system that would be held in trust under this reservation lands. They also said that they did not want to be second-class citizens and living on reservations, and at the time they thought that they would actually be restricted to the reservation land. Alaska Natives clearly wanted to have ownership and control of their lands. So we begin the issue, we begin to see Native people organizing to enact ANCSA, and we could see the two differences here. Congress really wanted to have clear title to Alaska because it was necessary for economic development. They also wanted to terminate that trust relationship, and they wanted to assimilate Alaska Natives, which they thought they would be able to do with fee simple title, cash settlement, and the corporate structure that would individualize the tribal members. Native people, on the other hand, wanted ownership of their land, and they rejected the BIA control of their lands. We also looked at the conflicting values. And we look at Western society and we see that individualism is a strong cultural value. They see land as a commodity, and the transfer of land or property is through inheritance or purchase. Well, Native people, on the other hand, had a communal orientation rather than the individualistic orientation. They said that land embodies the social, cultural, and spiritual dimensions. And they also transferred land through the generations by tribal membership. If you were a member of a clan or of a tribe, you owned land because of that membership, not because you inherited the property. Go ahead. So language in the ANCSA held that its objective was to promote the social and economic welfare of Alaska Natives. We have 12 or 13 regional corporations established and some 200 village corporations. We also have the conveyance of 44 million acres of land and $1 billion. ANCSA also extinguished Aboriginal hunting and fishing rights, but the Conference Committee of Congress was very clear in saying that Congress intended to protect subsistence, and this became a reality in the 1980 Alaska National Interest Conservation Act. So we have the passage in 1971, but by the 1980s, the Alaska Native people began to realize the flaws and the dangers of ANCSA. In 1982, we have the AFN convention meeting, and the delegates direct AFN to make the 1991 issue its top priority. The 1991 reference was to the provision in ANCSA that would allow for the lifting of the restrictions on the sale of stock in 1991. Alaska Natives had become increasingly concerned that they could lose their lands with the sale of stock to non-natives or through taxation and bankruptcy. They also had other concerns with ANCSA, notably the fact that their children who were born after 1971 were excluded as shareholders. AFN convened a series of Native leadership retreats and also 7 conventions to address these issues and also to develop proposals to amend ANCSA. The 1984 retreat that was held in Kotzebue was really very interesting in that this retreat, the Native people began to identify what are the Native values that we want to protect through ANCSA. And the first one that they identify is a communal orientation. And they said this communal orientation is based on our extended kinship system and the sharing of resources, including collectively raising children. This is one I hadn't known about, was that they saw it was a communal responsibility to raise children. They also talked about the respect that they had to have for elders, and also that that sharing was a bond. It served to unite Native people in this communal group that they lived in. They also identified land as an important value. And they viewed their relationship to the land very much like how they viewed their kinship relationship. And they said that subsistence was necessary for not only for their physical well-being, but also their spiritual well-being. And they also said that they have a trust obligation to pass their land on to their children. And then the third Native value they identified was Native identity. They said this is a significant Native value. So these values are the ones that became the basis for the development of the amendments that they were going to bring to Congress. But we have Secretary of the Interior Hodel opposing the Native amendments, and he outlines very clearly what his opposition was based on. He said we have the primacy of individual rights over group rights. He was opposed to the automatic extension of stock restrictions that would allow for the protection of Native lands. After all, ANCSA was meant to be an assimilationist model. And he also said that if you issued stock to natives born after 1971, it would dilute the value of the settlement for existing shareholders. So the 1991 amendments were adopted and signed into law in 1988. Its basic provisions called for the protection of land and also Native control of the corporations. It restricted the sale of stock. It also had provisions whereby stock could be issued to natives born after 1971 and also to left-outs, those who had missed the enrollment, many of them who had been serving in the military. It also recognized another Native value, and that was caring for the elders, and so it said it allowed them to issue stock to elders or else to set up settlement trusts. AFN was not able to secure the tribal option, which would have allowed for the transfer of Native corporation lands to an IRA or to a traditional Native council. Congress was adamantly opposed to this, but Native people were able to secure a disclaimer clause that ensured that the amendments, the 1991 amendments, would not validate or invalidate the existence of Indian country, or that a Native institution does not have governmental authority over lands or individuals within Alaska. So it was trying to say that the 1991 amendments was maintaining the status quo. But as I noted, it did recognize Alaska Native communal rights, the protection of land ownership, and the rights of children to land ownership and their identity as Alaska Natives. Native corporations went a little bit further, and they secured the right, a legislative right, to have consultation where the federal government would meet with ANCs as tribes whenever they were talking about issues that would affect Alaska Native corporations. And this was a result of when the pipeline, they were doing the reauthorization of the pipeline. and they were not consulting with the ANCs, but rather with the tribes. The ANCs were the owners of the land, so Native leaders went to Congress and were able to secure a legislative requirement for consultation. They have also gone to Congress a number of times and have secured 117 federal acts that say that Native corporations are tribes for special statutory purposes, not for the purposes of governance, but for these special statutory purposes. We also see ANCs acting to protect Native cultures. They provide financial and political support to AFN to advocate on behalf of Alaska Natives. They create and support cultural foundations, and importantly, it's been said that they provided up to $20 million for the protection of subsistence. So the question that we now have before us is, has ANCSA been a vehicle of assimilation of Alaska Natives into Western society, or has it been a vehicle for cultural survival? So when we look at ANCSA, we see that land was the major provision, and the form of ownership and use was transformed under the settlement. Additionally, Alaska Natives secured title to only about 12% of the lands that they once owned. Land was transferred to Native corporations under fee simple title, and land held under fee simple title had the potential to facilitate change in Native society. If we look at their traditional economy, we see that land and the natural resources were traditionally used for food and utilitarian purposes, and also the arts and crafts could be sold, or the byproducts of subsistence resources could be sold as a source of cash. But ANCs, as profit-making entities, use land for economic purposes to generate financial capital. It's also important to note that ANCSA also selected historic and sacred sites for their cultural rather than their commercial values. Looking at Southeast Alaska, we can see that of the 23 million acres in Southeast Alaska, Alaska Native corporations have harvested a total of 340,000 acres of land, or 1.5% of the total land base. So although we have these commercial developments of ANC lands, and we see that it does have impacts on the land and the environment, the data does not indicate that commercial activities on ANC lands have been diminished or replaced the subsistence economy. The existence of dual economies in rural Alaska is well established. We know that subsistence is an important indicator of the persistence of traditional culture, and we see this particularly in the rural communities. ANCs have been at the forefront in expending political and economic capital to protect subsistence. We can assume that subsistence rights would have been seriously undermined had not the ANCs used their financial and political capital to support subsistence. We also see that ANCSAs have largely maintained their land ownership of lands except for home sites. And in Southeast Alaska, we have 2 village corporations establishing home sites. And when we looked at the data more than 10 years ago, I haven't had a chance to update this part yet, we see that 40% of these home sites have been sold to non-natives and lost to native ownership. Now, insofar as the capital economy, we see that from first contact, Alaska Native people eagerly sought the benefits of the capital economy. And the legislative history of ANCSA also reveals that Native leaders saw ANCSA as a means to develop the capital economy in their communities, and in which they would become owners of the businesses. During the 1970s and 80s, we see Alaska Natives, particularly women, moving into the workforce largely as a result of the oil pipeline and also the state capital funded capital projects in rural communities. The state is coming into a lot of money at this point in time, and so they have a lot of capital projects in rural Alaska, and this is where Native people are going to work. During the same period, we see ANCs increasing their employment. However, even with the shareholder preference priority, we see that in the early years that most of the employment, particularly in the professional positions, went to non-Native people. But as Native people are increasingly becoming educated, they're moving now into these professional positions. However, during the last decade, we've seen a decreasing availability of wage jobs in rural Alaska, leading to an outmigration to the from the villages to the urban centers, which conceivably could have an adverse impact on Native culture. Sealaska has formed Ha'ani to promote economic opportunities in rural communities that we hope will attract Native people back to their home communities or allow them to remain in their homeland. Now, here's something I'd like to bring to you. I suggest that the adoption of a resolution to allow for the issuance of stock to Native people born after 1971 is a significant indicator of assimilation, measuring the adoption of Western values and norms or the persistence of Native cultural values. Corporate stock is acquired through a purchase, gifting, or inheritance, but not generally given without a payment. Non-Native corporations do not give away give away stock to thousands of new shareholders by a vote of their stockholders. In the ANC case, individual stockholders are asked to vote on a resolution to allow Natives born after 1971 to receive stock without any payment in the face of diluting the value of their individual stock. Now, I realize that this is a very simple, assertion about a very complex issue, but I also argue that it offers a very concrete measure about the persistence of group values versus the individual values. In voting to give stock to Natives born after 71, the individual shareholder is asked to choose between group rights of Native societies or individual rights of Western societies. 4 regional corporations have adopted this resolution, including ASRC, Doyon, Nana, and Sealaska. They voted to provide stock to children born after 1971. These ANCs have also replicated a form of tribal membership by making the enrollment of succeeding generations of Native people perpetual. In Southeast Alaska, in conformance with our traditional value of Hashigun that recognizes our ties to our ancestors and also to our future generations, shareholders voted in 2007 with more than 56% of the outstanding shares to enroll Alaska Natives who were born after 1971. Moreover, they voted to extend this in perpetuity. The persistence of these cultural values was again demonstrated in 2009 when the shareholders went again to the poll, and in this instance, by an overwhelming vote of 76%, they vote to give additional shares to elders. And this follows on an earlier action that set up a trust, or set up funds rather, to give each elder $2,000 upon the age of reaching 65. So clearly, these are Native values. So looking at the cultural persistence of Alaska Natives, we could see that indeed, there's no doubt about it, that they have adopted many of the patterns and norms of the American society. However, it is equally clear that they have not abandoned their cultural traditions. On the contrary, Alaska Natives living in both rural and urban communities are initiating efforts to revitalize their languages and culture. And we see that the Alaska Native corporations have provided considerable financial assistance to try to support these efforts. In Southeast Alaska, we see the persistence of a clan system, and we see that they have a very active ceremonial life, with thousands participating in the annual round of memorial traditional rites. In these ceremonies, again, in contrast to Western society, we see where a hosting clan will distribute up to $50,000 in cash to the guest clans. In addition to that, they may distribute up to another $50,000 in goods to the guests. And they also serve an enormous amount of subsistence and commercial foods to the hundreds of people who will go to these ceremonies. So in conclusion, we see that Alaska Natives have been changing since their first contact with Westerners in 1741. They have adopted many of the cultural norms and practices, but they have also retained a significant elements of their traditional values and practices. We also recognize that indeed sociocultural differences exist among Alaska Natives. There are some who are immersed in their traditional culture, while we have other Alaska Natives who rarely, if at all, participate in traditional activities. But overall, Alaska Natives maintain elements of their traditional culture which are distinctly different from the larger societies. Alaska Natives have also maintained the special legal rights that they have as that set them apart from other citizens. They remain distinct not only as a racial group, but also as a political group that has been recognized by the courts and Congress. I'd also like to emphasize that Alaska Native corporations are but one institutions that are affecting the lives of Alaska Native societies and stimulating sociocultural change. ANCSA has not been the sole stimulus of sociocultural change and their assimilation into Western society, but through their political advocacy and their financial support of cultural programs, they have contributed to the survival of Native culture. Congress enacted ANCSA to promote assimilation, but ironically it also enacted into law a traditional value of sharing through a form of what I call corporate socialism. And this is embodied in Section 7I and 7J of ANCSA. 7I calls for the sharing of 70% of profits that are derived from subsurface and timber development. And then 7J outlines the distribution formula among the regional corporations and the village corporations, and also at-large shareholders. Corporate sharing was actually initiated by Alaska Native people themselves. I know this might come as a surprise to many people who say this was imposed on them, but a memo I found says that it was Native people that enacted or promoted the Section 7I, and under 7I we see that $1.4 billion has been shared among the Alaska-based ANCs. For Southeast Alaska or Sealaska Corporation, that's meant that they've distributed over $300 million, and more recently we're starting to get back money as other regions are developing their subsurface resources, and the price of gold and oil has helped out here, and so Sealaska has received $359 million. ANCSA has been amended multiple times to accommodate the needs and desires of Alaska Natives, and undoubtedly it will be amended to accommodate the further changing needs of Alaska Natives. The history of Alaska Native corporations in the last 40 years demonstrates that Alaska Native corporations our evolving institutions. Gunatish. 10 minutes to ask any questions of Albert. Okay, we'll have a test on that in 5 minutes. Well, thank you very much for being a very attentive audience. I know I moved very quickly through this very complex topic. I know probably a lot of Native people and non-Native people haven't, had this kind of perspective, because most often it's not Alaska Native people who are writing history and doing the analysis. But in this instance, it is, I take full blame or credit, whatever it may be. Go ahead.
I just have a quick request or question. You brought up briefly the potential amendment to have land put into trust for tribes, and I wanted to know, or hopefully you could share where that issue is today. Okay,
you would ask a very complex question. We actually, there was a lawsuit, Carcieri, that says that we cannot put land into trust. There is an amendment in Congress right now that would allow for putting land into trust. There are a couple of bills. One bill would prohibit the transfer of ANCSA lands to put into trust in Alaska. The Alaska Federation of Natives has consistently supported, and this is Sealaska at the table, has consistently supporting putting land into trust. And so we have a law right now before, or actually a couple of them in Congress, but we also have a legal challenge to the Secretary's determination that land, as a result of the Venati decision that said that land cannot, that ANCSA lands in Alaska cannot be considered Indian country. And so the Department of Interior, as a result of that, said that they could not put land into trust, and they were saying, and so Alaska Natives have challenged this in court. So we don't know where that court decision is, so it's still a question to be answered. Okay, thank you very much. So guys, have a good day. Thanks.